Unequally yoked matrimonial property rights is not a promise of law. Welcome to the 461st inaugural lecture at the University of Lagos, to be delivered by the Professor Oluwakemi Mary Adekile. In this inaugural lecture, we'll be taking a deep dive into the family law to look at when the marriage ends, who gets what, and does the law truly protect the interests of both spouses. Let's see what the law has to say about this.
Vice Chancellor, Management Services, Professor Oluwakemi, the Deputy Vice Chancellor, Academic and Research, Professor Matthew Inaugural, the Registrar and Secretary of Council, Mrs. Victoria Enrique, the Bertha, Mrs. Oluwakemi Adekile, the University Librarian, Professor Oluwakemi, the Provost, the College of Medicine, Professor Adekile, ably represented by the Deputy Provost, Professor Daniel, the Dean, Faculty of Law, Professor Abiola, ladies and gentlemen of the press, I welcome you all to the 461st inaugural lecture of this university and the 15th of the 2025-2026 academic session titled Unequally Yoked: Matrimonial Property Rights, Not a Promise of Law. Today is a momentous day for inaugural lecturer, Professor Oluwakemi Mary Adekile, who was born exactly 56 years ago today, precisely 3rd of June, 1970, in the later of 15. As she celebrates her birthday and also delivers an inaugural lecture, let me use this opportunity to wish for tradition. Long life, prosperity. Happy birthday. Our inaugural lecturer completed her law degree at Lagos State University in 1990, was called to the bar in 1991, obtained a master's degree in 1996, and a PhD in 2013 from the University of Lagos. She began her academic career as a lecturer at the Nigerian Law School in 1993 and joined the Department of Private and Property Law, University of Lagos on 4th of March 1998 as a lecturer 2, rising to the rank of Professor of Private and Property Law in 2021. He served as 4th Dean of the Faculty of Law from 2014-2016. Professor Adekile is passionate about using technology to advance knowledge across borders using her YouTube channel, The Law Professor. He has shaped ideas, policy, and law, and thought processes through her teaching and extensive publications in local and international journals, as well as her authorship of books. These include
the first section to infuse gender and human rights into the study of family law, and gender and law, Nigeria's first course-based text on the subject, which she co-authored. At various times, Professor Adekile has consulted with government agencies through expert papers on aspects of private law, including one that contributed to the inclusion of privacy protection in the law reform torts law, Cap L2 laws of Lagos State in 2003. She has contributed to the legal profession through teaching, research, and public lectures. She was the inaugural coordinator of the Anti-Human Trafficking Legal Hub in Lagos State, a project of the International Organization for Migration, which will use policies and processes to better protect persons from trafficking. Professor Adekile belongs to several professional bodies, including the Nigerian Bar Association, the Nigerian Association of Law Teachers, Social Legal Studies Association in the United Kingdom, and the International Society of Family Law. She is an associate member of the Chartered Institute of Taxation of Nigeria. A Sunday school teacher at the Redeemed Church of God, Professor serves on the board of Royal Heritage International School in Cage, Arrakech, Osun State. She's married and blessed children. Distinguished ladies and gentlemen, it is my pleasure to invite Professor Oluwakemi to deliver our inaugural.
Comparable students, gentlemen of the press, distinguished guests, ladies and gentlemen. Madam Vice Chancellor, to the glory of God, I stand before you today to deliver the 461st inaugural lecture of the University of Lagos, which is the 15th in the 2025-26 academic session. It represents a momentous occasion in my life, today being my 56th birthday. And this lecture coming 33 years after entering legal academia, 28 of which I have spent at the University of Lagos. The journey to this inaugural lecture began on the 4th of March, 1998, when I accepted employment into the Department of Private and Property Law. Prior to that, I lectured at the single campus Nigeria Law School, Victoria Island, between January 1993 and December 1997. Let me note at this point that an inaugural lecture should speak to the topic in the field of a professor's research, showcase their contributions to academia, and acknowledge those who have impacted the life and career of the lecturer. This I intend to do. The lecture title, Unequally Yoked, Matrimonial Property Rights, Not a Promise of Law, is delicate and emotive. On the screen, you can see two animals that are yoked together. It actually refers to the agricultural practice of using a wooden crossbar to join two animals together to perform a common task. And ideally, they should be of equal capacity. When you have this kind of yoking, what happens is that both animals are suffering. The bigger animal is doing more than it's supposed to do, including carrying the weight of the smaller animal. The smaller one seems to be doing less, but it's actually being pulled along and strained because it's being dragged along. When there is inequality and inequity, what happens in reality is that both parties would suffer. It's on this note that I use this analogy to depict the matrimonial property rights and implications in law. What does it portend for our lecture? Unequally yoked speaks to the status of inequity and inequality underpinned by religious, cultural, and social statuses in marriage, and not a promise of law speaks to the gaps in law which conspire with these identities to deny matrimonial property rights to parties. Madam Vice Chancellor, ma'am. Unequal property rights is disadvantageous to both parties. Where you have inequality, what happens is that one person is actually carrying the weight of two people, and it does not promote family health. In the context of this lecture, therefore, it is disadvantageous to the family unit. Why family law and why this topic? While I admit that I have been privileged to teach almost every subject in the Department of Private and Property Law, I have decided to choose this topic on family law for many reasons, some academic and some experiential. First, based on the significance of family law. Let me state at the beginning that family law governs every one of us, from cradle to grave. In fact, I can say that before you were in your mother's womb, family law knew you and gave you a status, whether you like it or not. And this lecture, I must also sound a note that it is not an advocacy for dispute or divorce or discord in marriage. When you look at the lecture booklet and you look at page 16, you would see the socioeconomic and legal significance of matrimonial property rights, that it goes beyond the marriage of the parties, affects the children, affects even national development, because some of the issues underpin poverty, which is one of the indicators of sustainable development. Let me also note at this juncture that even from a biblical perspective, property rights are of interest to God. If you look at the book of Numbers 27:1-11, you would see there where God validated the rights of women to inheritance against the patriarchal system in Jewish system, which allowed only succession to male children. 5 daughters of Zelophehad had to consult Moses for validation of their property rights when their father died. And God said, yes, go ahead and give them their rights. So there are justifications for interrogating these aspects of the law. I've also observed over the years that there has been no substantive reform of family law. You might have reforms in other areas tangential to it, but substantive family law has seen few reform efforts. And I will say that this is not a coincidence. What do I mean by this? It would appear that we shy away on the basis of custom and religion from a reforming family law, because some people hold these systems as immutable normative systems. Yet I submit, Madam Vice Chancellor, without equivocation, that it is the most egregious act of negligence to avoid reforming family law, as sooner or later the dereliction will catch up with us and haunt us all. Reforming family law, therefore, is imperative. On the experiential level, Madam Vice Chancellor, let me give you a historical context. As a child in primary 2 in the 70s, I woke up one day to a dispute between my parents who were divorced. And this dispute related to the care of myself and my sister. And I suddenly found myself before a man that I regarded as a very big man or the big chair. I later realized that this big man was a customary court judge, and he gave an order within a space of 24 hours that I live with my dad in the middle of school year. That decision ensured that I attended 8 primary schools. And I got to know that what the judge did was to give a patriarchal order that validated the absolute right of the father to custody of the child, irrespective of the best interest of the child. Thankfully, this is no longer the case under the law. What are we looking at today under this topic? Madam Vice Chancellor, The topic speaks to the fact that marriage promises equality and law delivers inequality in property rights. And the key problem that this topic generates is, on the one hand, the romantic ideal as against the legal reality. There is always the constant conflict between family lawyers and property lawyers. A property lawyer tries to look at a property dispute and determine who is the owner of the property. A family lawyer tries to look at a dispute and tries to say, who should we give this property to? And the challenge for law is to determine the best way to fashion out an equitable ownership and distribution of matrimonial property system in the society. What is the scope of our lecture? The lecture focuses on statutory marriage and cohabitation for very good reasons and excludes customary and Islamic analysis. And you might ask yourself, why statutory marriage when the outcry has always been against customary law, customary practices, and what have you? And I must admit from the beginning that there has been a lot of judicial affirmation and of unequitable pronouncements regarding customary practices, family law, and succession rights, particularly regarding the rights of women to succession to property, as seen in cases like Mojeku and Uchiku and Ukeje and Ukeje. So, customary law is always under constant scrutiny. But when it comes to statutory marriage, on the other hand, there are few legislative reforms or even inquiries in substantive family law. Statutory marriage, therefore, has few judicial assessments and has hardly been touched since it was imported over 100 years into the country. It is therefore pertinent to focus interrogation on the supposed perfection of the statutory marriage. In a lecture of this time, it is impossible for me to go through the entire gamut of a lecture of almost 100 pages. Before you on the screen, you have the abstract of the lecture and what you would expect to see, which I know that you have copies of the lecture before you. So I will not pretend to go through everything that is in that booklet, but I would try as much as possible to look at what underpins these various issues that you have demonstrated on the screen. The core thesis, Madam Vice Chancellor, of this lecture is that matrimonial property rights in Nigeria are unequal, they are uncertain, and they are unjust. They are unequal, they are uncertain, and they are unjust. And they're unequal because marriage creates structural inequality in the gender roles of husband and wife, but law assumes that they are equal. They are uncertain because Nigerian law relies exclusively on judicial discretion in the determination of these property rights because there's no statutory legal framework. And unjust because we utilize a property law approach that I've talked about earlier to determine marital disputes regarding to property or to validation of property rights. Madam Vice Chancellor, it's always interesting when parties in a statutory marriage recite the vow, "With all my worldly possessions, I thee wed." The truth is that this is more of a romantic statement. It may be validated by the courts of heaven, but Nigerian courts that men sit over do not recognize that you marry with your property. You do not marry with your property. As far as Nigerian law is concerned, therefore, it has no promises regarding matrimonial property rights. What are we talking about when we talk about matrimonial or non-matrimonial property? Madam Vice Chancellor, globally there are two regimes that assist us in determining whether a property is matrimonial property. In this context, joint property that belongs to the husband and the wife. And these regimes determine the classification of matrimonial property. Now, because of that, there is no general definition of matrimonial property, and it's a reflection of the regime that is in operation in any jurisdiction. There have been judicial attempts in some countries to provide a definition of matrimonial property. But in the context of what we have in Nigerian law, I have proposed the definition that represents what is on ground today, that the property of a marriage can only be regarded as matrimonial property, that is the joint property of the husband and wife, if It is jointly titled, number one, in the name of the married couple, and it is utilized by the family and is judicially construed as matrimonial property after clear evidence of direct financial contribution to its acquisition or development, or through the trust regime. So unless you can show any of this, the property is actually held by either of the parties. It could be real property, which is the most contested form of property, but it could also be personal properties like cars and other forms of chattel. And even in modern times, you have disputes about intellectual property rights and whether copyright is matrimonial property. And in some climes, like New Zealand, they've actually held that even copyright constitutes joint property of the husband and wife, such that you must give some consideration to the other spouse. For the law to give you promises and give you some validation regarding matrimonial property, it expects you to be a bookkeeper or an accountant, to keep a record of all that transpires between you and your spouse financially. Otherwise, matrimonial property rights is not a promise of law. What are these rights? Madam Vice Chancellor, they are a bundle of legal rights which determine how spouses interact with property. Even though we have properties that we use together as a family, when there is any dispute, these legal rights will attach and define who actually owns the property. And I would also usually tell students, for instance, you can be driving a car and the policeman will stop you and say, who is the owner of this car? And say, it's my car. Even though the title to the car is not in your name, it's in your spouse's name. And they may accept that. But when you come before the courts of men, that will not be a valid statement. Now, the core areas that matrimonial property rights govern relates to ownership of property, division, on separation, or on succession. And the legal foundation can be found in family law, property law, succession. In fact, family law is a very greedy system of law because it borrows from every other aspect. When you're talking about family law, you're talking about almost every other aspect of law, criminal law, the law of evidence, and what have you. And the key question that every legal system must interrogate is how to determine the best matrimonial property regime that protects spousal vulnerabilities. What access should constitute matrimonial property rights? And how do you safeguard the interests not only of the spouses, but of third parties, like mortgagees and purchasers of property from either party to the marriage? The theoretical approaches to matrimonial property rights are underpinned by how the law constitutes marriage. Some systems regard marriage as a partnership, and every property that comes into that marriage is regarded as joint property belonging to the husband and wife. And they usually require that you have joint title to that property, such that if the marriage comes to an end by death or separation or divorce, the law will automatically divide property, into 50-50. And it is that 50% that you are entitled to give to your heirs-in-law, for instance, or to do whatever you like with. So in some other climes, like Nigeria, we adopt the title any share approach, where even though most of us believe that marriage is a partnership, but the law does not work in tandem with that. It requires that every one of us establish that they have a financial contribution to a particular property before it becomes matrimonial property. So that's what we call title or any share approach. And that's what we call separate property regime. So you're not wed with your property in that kind of system. Now, law and ownership and division of matrimonial property in Nigeria. Madam Vice Chancellor, let me give some historical context to the statutory marriage that we are looking at today. It's an imported form of marriage from English law. Under that system of law, when there is marriage between a man and a woman, the law, common law, regarded the marriage. I'm sure most of us are also familiar with the vow. When we get married, the two shall become one. That one represented the husband. The identity of the woman is completely obliterated in law. She has no capacity to relate with anybody under the law without you joining her husband as a party. She could not sue and be sued alone. She could not enter into contracts, could not, be sued in tort. She lost her identity. That one meant the husband. She was a woman under coverture. And this resulted in a lot of injustices to married women because some husbands were prodigious in the way they led their lives, and some of them even deserted the marriage and left the wife and the children destitute. The challenges created by this led to the promulgation of the Married Women Property Act, which gave married women separate legal identity and gave them the capacity to have property relations in law. And that is how we got into the concept of separate legal personality and separate property rights in law. So now the law, because this law is part of Nigerian law, and now presumes that the husband and the wife are equal before the law and they are entitled to acquire their own property. The challenges that this creates relates to the fact that even the Married Women Property Act and the various state interpretations in Nigeria do not confer property rights, but only interrogate and find out who is in charge, who is the real owner of property. Madam Vice Chancellor, while the Married Women Property Act has improved significantly the status of married women under the law, the snippets of coverture still rule us from their graves, because the shackles of structural inequalities and inequities in marital norms are still prevalent. And this is why we are interrogating this topic. The problem in Nigeria, Madam Vice Chancellor, is that there are many cases that have come before the courts and have emanated from what we call separate property rights, which means that you do not have automatic ownership or co-ownership of property that belongs to your spouse under the law. The law requires you to prove financial contribution before you can have an interest in it. And it does not recognize indirect contributions. When I say indirect contributions, that is any other thing you do in a marriage is inconsequential to the law, like taking care of domestic activities and what have you, which we'll be looking at later. Now let's look at some of the issues that have risen in law. You have cases where a husband will have sold the property and the wife refused to leave the matrimonial home because she maintains that it's a joint property. Some will say that they were the ones that bought the cement. Some would say that they decorated the home. You know, all sorts of assertions. You have situations where some will come before the courts and allege that there was an oral agreement between them and their spouse, that while they use their money to take care of the home, the husband had promised to use his money to build the assets of the family. And when there is now a problem in the marriage, because we adopt a property law approach, the law only looks at where is the title, whose name is on the C of O, for instance, and that is the basis on which it would determine the dispute. You also have situations where some spouses, what we call working or schooling spouse syndrome, whereby a man or a woman would have sent their spouse to school or supported their professional development financially, and when that person has acquired a different status, they say they are not interested in marriage again, and the degree has been the question arises, is the degree a property? Now it's a personal property, it's an intangible, it cannot be shared. So there are jurisdictions that have now developed compensation approach, that if you abandon a spouse after that person has trained you or has done something to assist you in your career, you should pay compensation regarding that. Let me now go to one that is very important to a lot of us, the matrimonial home. Madam Vice Chancellor, the matrimonial home, let me assert categorically that the term is a social and not a legal term in Nigerian law. It is rather disheartening that in Nigeria there is no legal concept of matrimonial home, even though most of us are fond of saying my matrimonial home, matrimonial bed, matrimonial this or that. It is a social statement, not a legal statement. And that is why you see, for instance, when you watch Africa Magic, you will just see a couple in a palatial residence, and suddenly, because of what the woman has done, a simple misunderstanding, they carry a Ghana must go and say that is her property and throw her out of the home because she has no interest in that property. It is titled in the name of the husband. There is no such concept of matrimonial home. Evicting a spouse from the matrimonial home is a serious issue, which, for the serious impact it has on the victim, when it happens, justifies specific legal intervention in family statutes. We need intervention, in family statutes. It is high time that the matrimonial homes rights be recognized in Nigeria. In English law, you have what they call statutory occupation rights such that protects even the non-owning spouse, even though you are not the owner of the property. The property is in the name of the wife, for instance. The wife will still be unable to throw out the husband from the home. So this occupation right can be found under the Family Law Act of English law, and I recommend the same for Nigeria to protect the institution of marriage. Domestic contribution is another problem under this area of the law. What do I mean by domestic contribution? Relates to things like childcare, home management, emotional labor, all sorts of things that we do for love. One thing that features consistently when proprietary interests arise in matrimonial conflicts is what to do with domestic contributions and the matrimonial home. So domestic contributions are one of the economic sacrifices of marriage. You and I know who does most of those works. Domestic work is indirect contribution to property rights, and it's of no legal consequence. Because when the law is interrogating the property rights, it is not looking at that, it is looking at whether you made direct financial contribution to the particular property before the courts, not contribution to the marriage under Nigerian law. You can contribute, and you have cases, a wife cases where some will say, I contributed furniture, I painted the house, I did landscaping, both in English law and Nigerian law. All these cases, courts have rejected them, that they are not sufficient to confer matrimonial property rights on the couple. This is why we say matrimonial property rights is not a promise of law. These are some case examples. Only last year in Essien and Susan Ohio Investment Limited, the Supreme Court said for a spouse to be successful in his or her claim of an interest in the property of the other spouse, he or she must prove the financial contribution made towards the purchase or development of the property in dispute based on the rules of property law, not family law. So you have a family problem with a property solution. You can imagine what is going to be the result. You can also see the same approach in the case of Nwaya and Nwaya, where the judge said that a wife should produce the receipt that shows that she contributed to the matrimonial property. If she bought building materials and gave it to her husband, she was duty bound to lead evidence in support. If her monetary contribution was by way of a check, evidence ought to have been laid. When this case was decided, it was not the age of technology. And you and I can imagine how many husbands and wives will sit down in their bedroom and be writing down their interaction regarding how they are running their home. So these are some of the things that have happened in law. You also have a claim in Essien and Essien where she said they had an oral agreement that the husband will use part of his money, towards development of the house, and she would do otherwise. But the court rejected all these kinds of situations. And that is why we are saying that matrimonial property rights is not a promise of law in Nigerian family law. These case examples lead to the dominant conclusion that the dominant position in Nigeria's separate property regime seems to be that what we do for love does not stand in law. A spouse must establish expenditure directly relating to the acquisition or development of the property in dispute, not that you are contributed to the marriage itself. What is the consequence of this approach? It leads to gender inequality, economic vulnerability, marital instability. And interestingly, it has been noted even years ago, and we are still in the same position by Uwogu, when he said that in Nigeria, the realities of family property has changed substantially, while the applicable law has remained the same. In traditional Nigerian society, the husband was the breadwinner and provided not only the matrimonial home, but also the resources for the upkeep of the family. The wife was in the main the home keeper. With social changes, the position has changed, particularly the growing middle-class families. Wives not only keep the home, but are in many cases employed, thereby making substantial contributions to the family income, including the construction and maintenance of the matrimonial home, which is often exclusively in the man's name. On the dissolution of the marriage, the wife is jettisoned and expelled from the home, denied any interest therein. Indeed, Madam Vice Chancellor, matrimonial property rights is not a promise of law. One of the key things that happens before the courts is the fact that we compare you compare apples with pears, homemaker contribution with money maker's contribution. One spouse is taking care of the home, the other spouse is taking care of capital investment. When you do that kind of comparison, you know, the apple and the pear are both fruits and they have the advantages. And you do not expect the apple to perform the role of the pear and vice versa. And it's been said that this kind of comparison is dangerous and they are not incommensurable and should not be done. In fact, what it happens is that when you ask parties before the court to come and prove their contributions in this respect, then you are creating marital instability, because when people are in marriage, then they are always looking back and trying to take account of what they have done and keeping records and marking scores about their contributions to the properties that they are acquiring, when they should be relaxed and know that this is a partnership. It is on this note that it is said that the law has not been beneficial when it comes to matrimonial property rights. The position under Nigerian law, unfortunately, because I said at the beginning of the lecture that we'll be looking at cohabitants and statutory marriage, and it's for very good reasons. Cohabitation is when people live together without being married and they create a family relationship. And ordinarily under common law, this kind of relationship is not encouraged. But you know that today, in this age, there are so many people that are in cohabitation, either intentionally or unintentionally, due to a purported marriage that turns out to be fake or to be false. Now, Madam Vice Chancellor, it will surprise you to know that under Nigeria's separate property regime, which holds that marriage does not confer property rights on spouses, there is actually no difference with this state of affairs and the treatment of married couples. When you say that property is separate property, there's no difference between the status of married couples and cohabitants. Unlike what you have in a place like English law, where there's a marked difference. If you have a case relating to marriage, what you discover is that in that kind of a situation, the law under the English Matrimonial Properties Act of 1973 has created a yardstick of equality, whereby it has a notion of equality regime. Parties have equal rights to property, and the court have the statutory mandate to do equitable redistribution for married couples in Nigeria. For this reason, Madam Vice Chancellor, I recommend that there must be a marked difference between cohabitation and marriage under the law. There are vehicles that the law tries to use to assist couples that are married. One of them is the law of trust and its interpretation of property rights. And a trust is a legal relationship created inter vivos or upon death by a person, the settlor, in which assets are placed under the control of a trustee for the benefit of a beneficiary or for a specified purpose. And any person, including a married couple, can be a beneficiary of a trust. In this presentation, Madam Vice Chancellor, I'll concentrate on two: the resulting trust, purchase home resulting trust, and the constructive trust. And the purchase home resulting trust under English law, which we have imbibed, says that if we are, for instance, in some cases, for instance, you have a man who buy property and put the name of his wife, because maybe he doesn't want his employers to know that he's the owner of the property, or he's trying to avoid scrutiny of the law. When you do that, you buy property in the name of another person, the law will presume a resulting trust. It's a rebuttable presumption. You can come to court and show what you actually intended, but there's a presumption of a resulting trust in favor of the person that financed the property purchase. Then you have the presumption of advancement also at common law, which is a result of coverture. Recall I said that married women were under the coverture of their husband. In this context, where a man buys property in the name of his wife and he finances it and puts the name of his wife, common law presumed that he intended to advance her, to give her a gift, because she's under his cover anyway. But there's no same presumption regarding a man, because a man is not under the cover of the husband. Today, because women have tried to attain equality under the human rights regime, and we say we are all equal, there are now decisions that have asserted that this presumption can no longer stand, because both of you are equal under the law. Then you have the constructive trust. This trust requires that when you have this kind of property dispute to say, oh, I'm the owner, or we are joint owner of a property, you must come to court and show first common intention by the husband and the wife that intended the property to be joint property. And this your common intention must not be assumed. You just go through the marriage and assume that because we are married and I'm doing my part, he's doing his part, that property is our home. The law is not going to accept that. It says there must be some expressed or what it can imply as an intention that you should hold property as joint property. And secondly, you must ensure that you prove detrimental reliance. Madam Vice Chancellor, it will surprise you to note that, again, trust in interpreting detrimental reliance says that there must be direct financial contribution to show that you relied on the common intention. So when you cannot show direct financial contribution, trust is unhelpful to you. Again, matrimonial property rights, therefore, is not a promise of law. So if the law as it stands is not helpful, what do we do? Can we agree together as a husband and wife and sit down and have an agreement? So you talk about marital agreements, whether prenuptial and postnuptial. Common law did not accept marital agreements because it felt that it is unquestionable and will lead to marital disintegration. How can you sit down in the marriage and be planning, if a marriage breaks down, this is how we will share the property? So it's contrary to public policy in the eye of common law. But so it did not accept it. Usually these agreements relate to how you share your property and assets and finances and arrangement during the marriage. But in modern times now, it has evolved to the situation where if you can show that you freely entered into the agreement, the husband and wife, and they understood what it meant, and it is fair in circumstances, the court has a discretion to an extent to accept that kind of agreement. But it is not binding on the courts. And this kind of position is in English law, and it's only of persuasive precedent in Nigeria. In Nigeria, there's a legal gap. The Marriage Act and the Matrimonial Causes Act of Nigeria actually seems to have created only a regime for celebration of marriages and dissolution. What happens in between, there is nothing under the law. And so there is a gap and no express provision, and that is why, Madam Vice Chancellor, I am recommending that there must be specific provisions regarding marital agreements under Nigerian law. Now, because we have seen that the law does not encourage and does not, in other Nigeria, does not, accept that marriage is a partnership of property rights, and your property remains your property, my property remains my property in marriage. There are concerns, as we have seen in some of the cases that we have talked about, and that is why I'm making some proposals for reform. We need a new Family Law Act in Nigeria. Family law is one area that we shy away from. And the MCA, like I said, was enacted the year I was born, 56 years ago, and has not seen any substantive amendment or reform since then. I'm also proposing that there should be a new family law statute to cover the definition of matrimonial property and define contributions to property beyond saying that contributions should be financial contribution. The courts lack express redistributive powers in Nigeria. The most that we have is settlement of property under the Matrimonial Causes Act, which does not confirm property rights, so to say. It's just an equitable approach to give some residential accommodation to parties when they are divorcing. So we need clear laws that create statutory occupation and shared home concept, such that it is impossible to evict one spouse from the matrimonial home. And we need provisions regarding marital agreements as well. But the question most important for us in this gathering is to determine, do we think that the separate property regime that we operate in Nigeria is the ideal regime? Or is it not time to begin to interrogate and look at the kind of matrimonial property regime that meets the needs of the family law system that we operate in Nigeria? And that is why mostly the starting point is actually the deferred community or property regime, whereby during the marriage you still maintain your individuality, but at the end of the marriage, the courts have some express powers to interrogate the marriage and give some power and readjustment to property rights. I'm also advocating, Madam Vice Chancellor, for judicial activism in this respect. While it has been recognized in most climes that statutory reform is the only way that can confirm matrimonial property rights, the court can do a lot in promoting and stimulating that kind of reform. And you have had some snippets of judicial decisions which have attempted to create equitable matrimonial property rights. In fact, there was a case regarding customary law marriage in Toyin Arabilu and Solomon Monday, where a court allowed a customary law wife to have some property rights in the in a divorced husband's property. Even though customary law does not recognize property rights after divorce, under customary law, it's often said that even women themselves are property to be inherited by their spouses, and so there's usually no property rights. But you have some pronouncements that are equitable in that respect. There is also the need for personal initiatives. In this respect, the world is changing, and there are some, like I said at the beginning of the lecture, my intention is not to promote that there should be disputes in property, but rather, the Bible says, my people perish for lack of knowledge. Knowledge is power. And when you are properly enlightened, you can make some important decisions. Because the provisions regarding matrimonial property rights particularly impact succession rights. Your marriage impacts your succession. If you don't make a will and you die intestate, the kind of marriage you celebrate has implications. And that is why we are recommending that personal initiatives like personal transfer of property, making of wills, intervivor dispositions, and what have you, and even establishments of trust for transfer of family wealth should be done. And then there are academic initiatives. Madam Vice Chancellor, part of these initiatives will include the fact that we need to actually begin to embrace family law centers in our universities, and I will be proposing one for the University of Lagos immediately after this lecture. We need a family law center that will address this and begin to stimulate legal reform in this respect. Madam Vice Chancellor, I have almost completed a Model Family Law Act that would assist in the reform of family law, and it will be coming out immediately after this inaugural lecture. Marriage is a partnership. I believe that every one of us believes so when they are getting married, but Nigerian law does not reflect it when it comes to property rights. It creates a separate property regime under the law. Madam Vice Chancellor, it has been abundantly clear that in Nigeria, matrimonial property rights are not a promise of law, and the law expects you to do something to get your property rights protected. It is my hope that this lecture would stimulate an understanding and discussion of the needed reform initiatives under this area of law. Family law must be an instrument of social change so that matrimonial property rights may be a promise of law. My contributions. Madam Vice Chancellor, I've spent 28 years at the University of Lagos, and I've been involved in leadership roles and other areas of the law. We normally say in academia, you're supposed to do teaching and research and community development. And I must say that I've been very involved in all these areas. I was sub-dean of the Faculty of Law between 2014 and 2015. And I've also served in various capacities administratively. I've also been involved, Madam Vice Chancellor, in institutional leadership, including chair of various committees and boards, including as currently the chairman of the Auditorium Management Board, which includes this auditorium that we are seated in, at the kind behest of Madam Vice Chancellor. This is an overview of my service to the university in teaching. I have PhD students under my supervision. I've published books. And because of my YouTube channel that I run to disseminate knowledge, this was what encouraged the Dean of Law to mandate me to help in establishing a Faculty of Law recording studio for the purpose of recording lectures for the Faculty of Law. And other departments and faculties have tried to also go in the same direction. Contributions to research and teaching. I said earlier that I've taught almost all the subjects in my department over the years. I've listed and I've done research in these areas. I have 2 books in the field of, I have a book in family law and a co-author of gender and the law, and I have other books in press as well. This is a picture of the Faculty of Law recording studio where we do our recordings for students. This is a picture of my family law textbook and the gender and the law textbook that I co-authored with colleagues in the department. And this is behind the scenes of the law professor as I was recording. Contributions to the profession also as shown on the screen, where you can see that I've been not only wearing my gown, but I'm also in town. I've also been external examiner and assessor to various institutions over the years. Acknowledgements. I want to bless the Almighty God for the privilege and grace to deliver this inaugural lecture on my 56th birthday. I am indeed a testament that with God, all things are possible. All I have to say is thank you, Lord. I want to thank sincerely the entire management of the university and the Senate under the leadership of our first female Vice Chancellor, Professor Folashade Ogunshola, OON, FES, for the privilege to deliver this inaugural lecture. My parents. Sadly, my dear parents are both late. My father, Mr. Jeremiah Akobi, was a lawyer himself and an alumnus of this great institution. He passed on 20 years ago. My dad's parental guidance led me to the choice of law as a profession. My mother, Princess Margaret Aderonke Adedejini Ademuroti of Ole-Ife, also passed on 12 years ago. May their souls rest in perfect peace. My mentors, my teachers, I have my teachers, some of them are online, including Honorable Justice Toyin Ikwaye of Lagos State High Court, Professor Ayodele Asenua, who is online, and even my secondary school teacher, Mrs. Dowu, who taught me literature and English, is online. My destiny helpers, as listed, my mentors and supervisors, as listed, and I also recognize distinguished Professor Taiwo Oshipiton, Senior Advocate of Nigeria, for his mentorship, as well as all the other mentors. The past faculty who have impacted my career over the years are well recognized. My professional colleagues, the Nigerian Bar Association, National and State, Lagos, and the Ikeja branch, I owe a debt of gratitude to them for their support in my career and for their successful publicity of this inaugural lecture and presence today. The judiciary, my sincere gratitude goes to the entire judiciary here represented by judges and magistrates. I also recognize particularly the Executive Secretary of Lagos State Judicial Service Commission, Mrs. Adebola Olabisi Odeyemi, and the entire commission for their support. My faculty, my colleagues, the Department of Private and Property Law, led by Professor Ego Chumba, my HOD, and my dean, Professor Abiola Soni, Senior Advocate of Nigeria, a brother and a professor with a prophetic tongue. I also recognize all members of the faculty as listed. God bless you all for your support. My friends and old school, all Sacred Heart Private School, Ola Queens, class of 81-86, and LASU class of 86-90, I appreciate your support over the years. Sisters for Life, they are all represented here. The wellness team, God bless you for being a pillar of support, as listed here. I want to thank my inaugural lecture planning committee, led by Dr. Folashade Adebite, chair, and Dr. Gwintola Akinwale, co-chair, made up of students, colleagues, and family members. My students, past and present, God bless you. 33 cohorts of mutually impactful relationship. May your journey be smooth and may you be better than your teachers. The Royal Heritage family, as listed, God bless you for your support that has sustained my family. The Redeemed Christian Church of God that I've attended, particularly the Redemption Pavilion Parish, Victoria Island, Lagos, led here by my pastor in charge of Lagos provinces, Pastor Bisi Olowoyo, and his amiable wife are well recognized and represented and acknowledged. My extended family, the Akobi family of Ile-Ife and the Ademuroti family of Ile-Ife, God bless you all. On this note, let me particularly mention my uncle, Mr. Gbade Elushakin, who is present in this hall. Mr. Gbade Elushakin is the only maternal sibling of my dad, and I want to appreciate him for his sacrifice to my dad and her in the 80s. If he did not intervene at a particular point in our life, I would have dropped out of university to support my dad. He's here present, he can hear us. God bless you, sir. My in-laws are all recognized as listed. My late father-in-law and my mother-in-law, who probably is listening, and my siblings' in-laws, they are a wealth of support over the years. God bless you. My siblings, Sheon and Olumide Oyawale and Gbega Kobi, Yomi and Bumi Adedeji, Tayo and Titi Adedeji, Ayo and Tope Adedeji, Ope and Sheifumi Adedeji, God bless you. Ikeji Arajeji community, led here by Kabiyesi himself, His Royal Majesty, Barrister Oba Barrister Adenle Adeloye, the Akeji of Ikeji Arakeji, God bless you, sir. God bless you, sir. Chiefs and the entire camp community in KG. The royal support here is tremendous. I recognize all the royalty here present. KBC, I also recognize our family friends, too numerous to mention, as seen on the screen. Too numerous. Ori Ofesha and Morigba, God bless you, sirs. Chief and Chief Mrs. Joseph Oladele Sanusi, OFRCON, former governor of Central Bank, Prince and Mrs. Oluwatoyin Adedoyin, OFRCON, Chairman, joining group of companies, and so many others as listed there. Time will not permit me to go through them. You are recognized by God. God bless you for being a pillar of support to my family, and I really acknowledge you. Yeah, they are still listed there. You can see many of them are here in the hall just because of us. They have been a pillar of support over the years. God bless you all. May your journey remain smooth and peaceful all the days of your lives in Jesus' name. I want to acknowledge all those who are physically and virtually present to this inaugural lecture for giving me just 1 hour of their time. My immediate family. My immediate family can form a fellowship. They can form a church and have the pastor and choir. God bless you all. These are my children, God's heritage. May you be better than your parents. May your journey be graced in righteousness, peace, joy, excellence, and success in Jesus' name. This is Tiwalade, final year law student. This is Aderi Sola, medical student, Idiaraba. This is Eyara, economics student. This is Josh Otumba and John Balogun. They are unavoidably absent. They are writing their exams right now, but join us shortly. God bless you for making parentage a delight. God be with you. Finally, I want to recognize my husband, the Prince, Adekile, Senior Advocate of Nigeria. I reserve special gratitude to my dear husband, the Prince himself, Emmanuel Adekile, Senior Advocate of Nigeria, whose love and leadership have shaped our marital journey. Thank you for all that you represent, both as a dependable husband and a committed father, to God's heritage in our custody. I thank God for His grace, which has gotten us to the top echelon of the legal profession, myself as a professor of law, and you as a senior advocate of Nigeria. Aderemi, this milestone belongs to you as it does belongs to me. This is one man, he will celebrate others, but he doesn't want to be celebrated. God bless you. God bless you. God bless you. Madam Vice Chancellor, this is my inaugural lecture.
Fantastic.
Thank you, sir.
Well done.
Thank you, sir.
Justice Ika Afolabi and other honorable justices who are here present, Mr. Larry Akinshola, SAN, our Royal Fathers, His Royal Majesty, their Royal Majesties, Dr. Arulu Fagidi Alaitu Baitu Vijay, His Royal Majesty Oba Isaac Adiyeba Ayeni Akila of Erisha, and His Royal Majesty Oba Adeyemi Adeyemi Akeji of Akeji, and Ashwani Yinka also recognize Pastor DC Oluwakemi the alumni, members of our ladies of Apostles Secondary School, NASU, and Law School, the entire members of our Adekile and our community families, the children of our inaugural lecturer, Tiwalade and Aderi, Iyara, Adekile, and Adekile. Last but not the least, the pillar, the support, Mr. Adekile, Emmanuel Adekile, you're most welcome. Deputy Vice Chancellor, Management Services, Professor Oluwakemi. Deputy Vice Chancellor, Academics and Research, Professor Matthew. The Registrar and Secretary of Council, Mrs. Victoria Osei-Cliff. The Bursar, Mrs. Adekile University Nigerian, Professor Latumo. The Provost College of Medicine, Professor Adekile, represented by Professor Daniel Devi. The Dean, Faculty of Law, Professor Adela Soni SAN. Distinguished ladies and gentlemen of the press. I'm sure you will all agree with me that today's inaugural lecture by Professor Oluwakemi was well delivered. The lecture titled Unequally Yoked, Matrimonial Property Rights, Not a Promise of Law, interrogated the challenges of matrimonial property rights in relation to statutory marriage and cohabitation in Nigeria, underscoring that while legal reforms and judicial activism have been dominant in customary law, there have been little efforts to reform the matrimonial property legal regime in statutory marriages and cohabitation. The lecture, while appreciating the overarching judicial discretion in settlement of matrimonial property, argued that issues of matrimonial property rights must be grounded in statutory provisions. In this regard, the lecture examined the separate property regime and the community of property regime along their variants, in concluding that none of the regimes offer a perfect approach to matrimonial property rights. Our inaugural lecturer argued that while most countries have developed equitable approaches that embrace the realities of marital life today, Nigeria is still tied to the vagaries of structural inequality that makes married couples unequally yoked, as the law has no promises of protection. Drawing inspiration from other jurisdictions such as Ghana, Uganda, and the United Kingdom that operate separate matrimonial property rights with wide redistributive powers, constitutional construction of joint property, and a statutory framework for equality, the inaugural lecturer recommended that a holistic reform of the family law is necessary to address the present inequitable division of matrimonial property that fails to take cognizance of indirect contribution by our women folk. She called for further academic interactions and research on the subjects, in addition to personal initiatives that provide protection from unfair and effective family law principles. Finally, she recommended the ratification and implementation of relevant human rights treaties on family law, as well as the enactment of a Family Law Act that will address the conceptualization of matrimonial property, the recognition of indirect contribution of spouse in the determination of matrimonial property, creation of statutory occupation and shared home concepts, and legal framework for prenuptial and postnuptial agreements. Ladies and gentlemen, you will all agree with me that the inaugural lecturer has done an excellent job defending her pedigree as an astute educationist, a legal luminary, and a distinguished scholar of our excellence. Professor Oluwakemi, congratulations on giving an informative inaugural lecture with immense contribution on improving our society and the world at large. Congratulations to you and the faculty. I thank you all for coming and wish you a safe return to your various institutions. I hereby declare this assembly closed.
Thank you very much, sir.
Well done.
Thank you, sir. Great. Yes, sir.
Baby girl. Matigato.
Yes, it's my message. Kiss now. Okay, it's for my brother.